Hey guys, and welcome back to the channel. Today, we've got two courtroom situations you don't want to miss. One features a pro se defendant who thinks he understands the law better than trained attorneys, and the other involves a self-diagnosed insane sovereign citizen clashing with a new judge and attempting the only defense that might actually work, an insanity plea. We'll start with the first defendant, who appears in court twice, once about a month ago and again just yesterday, so let's jump right in.
Turning to Ronald Hargrove.
Jonathan Baber on behalf of Mr. Hargrove.
All right. Is Mr. Hargrove here?
I do see a Ronald Hargrove name. There we go.
Okay.
George.
I think I just heard him. He's coming on. All right. Okay,
Thank you, Your
Mr.
Honor.
Hargrove. Go ahead, Mr. Baber.
Yeah, today is the date and time set for a couple of things. It's a status conference, Judge, but it's also a hearing date for my motion to withdraw. I'm really just going to rest on what I put in my written motion for this court. I really can't disclose too much more in regard to what the conflict is between me and my client without risking attorney-client privilege, and I don't want to waive that on behalf of Mr. Hargrove. But I do believe there's been a breakdown in the communication between me and my client. We just aren't seeing eye to eye on certain aspects, and I want to respect his wishes on how he wants to have his case represented. So therefore, I'm asking this court to consider withdrawing me from the case.
All right. Mr. Hargrove, well, first of all, Mr. Baber, you are appointed to represent him. Is that correct?
I am.
I do see that in your motion. Okay, give me just a second to...
And I want to stress to the court, too, that Mr. Hargrove has been very respectful. It's just a situation where we just do not see eye to eye on certain things.
All right. So, Mr. Hargrove, you understand what, without getting into details, because I've read the affidavit of Mr. Baber, but do you understand what he is saying?
Mm-hmm. Yes, sir.
All right. Now, if I allow him to withdraw, which is what I'm leaning towards right now, I'm not sure whether there will be another attorney appointed for you or not. I don't know.
No, I was just confused about a bunch of things.
Right. But, you know, when there's a significant disagreement as to how to proceed, an attorney cannot go ahead and present something to the court that the attorney believes is not justified by law or fact, even if his client thinks it is. So he can't do that if he believes, that's against the rules that we have to practice under.
Okay. Well, let me ask you a question.
But you can ask it, I'll answer it if I can.
Are you the trustee for the Cesta KV account, Ronald Gene Hargrove II, or any account thereof?
Are you asking me that question? I have no idea what you're talking about.
Sovereign citizens often believe that by declaring the judge a trustee of their so-called SSQV trust, they've magically created a conflict of interest that forces the judge to step aside. But to keep it simple, that's not how the law works. The judge is not your trustee, and no recusal is required.
You don't know
I
what I'm
suspect the answer is no, but we're really not going to go down that road. Right now, the only question is whether or not Mr. Baber should be your attorney or not. He's filed a motion to withdraw, saying that he can't. Basically, you have a disagreement on how to proceed. That's too significant for him to proceed.
Okay.
All right, so I'm going to allow him. Mr. Baber, was there an order that accompanied your motion?
No, Judge, I will prepare one and present it to the court by tomorrow.
All right, that's fine. I'll go ahead and sign that. Mr. Hargrove,
Yes, sir.
you wish to have another court-appointed attorney?
No,
Or do you want to represent yourself or hire your own attorney?
well, I guess I'm not going to get anywhere. No, my questions aren't being answered. So I don't know what to do.
Well, I need an answer. If you want to request another attorney, I can have, I can have you interviewed again by MIDC, they may or may not appoint an attorney for you or allow one. What do you want to do?
Well, I guess I'll go forward with an attorney, and
Okay,
because
so here's
I have a witness and some other things.
Okay.
I guess I need an attorney.
There's no guessing about it at this point. You sound like you grew up in the lead paint era and are already struggling to understand basic courtroom procedure, let alone serve subpoenas, file motions, or properly present evidence on your own behalf. And that's exactly why firing every attorney who tries to help you is the worst move you can make. So, for your own sake, it might be time to stop pretending you know more than trained professionals and start letting your lawyers do the job they were hired to do.
Well, I mean, it's up to you. I'm not necessarily going to appoint one for you. Ms. Parker, is Mr. Brown there?
Yes.
He has. He just popped on. Mr. Brown, this is a bit of a new one on me. I don't know if you heard it all. Mr. Baber was appointed to represent Mr. Hargrove. He withdrew because they had some disagreement on what should be presented to the court. And I've allowed the withdrawal. Mr. Hargrove still wants a court-appointed attorney. Does that have to go to Mr. Slough, or is he simply re-interviewed by you?
I don't necessarily know if he even needs to be re-interviewed unless things had significantly changed, as he did have a court-appointed attorney. So unless things have significantly changed, I don't think a withdrawal would require a re-interview. I think he would just have to be appointed another attorney.
All right, so we'll notify Mr. Gilo's office of that. Mr. Hargrove, that attorney would be appointed for you. You'll be given the name and number of that attorney. You should give them a call. Pam, if you called, or that attorney, would you also let them know they may want to call Mr. Baker?
I'll try to remember.
Yeah, okay, I get it completely. But Mr. Hargrove, I suspect that if this attorney has the same situation that Mr. Baber does, you may end up representing yourself or having to hire your own attorney.
Well,
Okay.
I wish you would just please answer my question.
Well, that's nothing that I can answer in a situation like this. The only question, you need an attorney, you've requested an attorney. If you're the next time you come to court, I won't be here because there'll be another judge. As my term ends at the end of this month, in about 10 days or so, 12 days. So any argument would be presented to them, but it has to be done according to the court rules that we're all bound by.
But you don't have to answer my question?
No, he doesn't, especially considering he's retiring at the end of the month, and a brand new judge will be taking over, which brings us to Judge Hesseling, who stepped into Judge Cooper's courtroom about a month ago and wasted absolutely no time getting his first sovereign citizen to deal with this one, actually has an attorney now, but somehow still manages to turn a simple hearing into complete chaos before things even get started.
All right, Ronald Hargrove, file 24-43189 ST. I see you, Mr. Hargrove, on Zoom. You represented by counsel, Mr. Hargrove?
I represent Mr. Hargrove, Judge.
All right, thank you.
What we're going to ask the court to do is accept the plea to count one with the second offense dismissed.
Mr. Fortier, is that an accurate statement of the agreement?
I don't know yet, Your Honor. I can't find the case for some reason.
All right, I'll give you a second.
Mr. Gilo, did Miss Brooker email you that offer?
Yes, on the 9th.
Okay. Then, yeah, Judge, that would be what we're gonna do then.
All right. Mr. Hargrove, you've heard the attorneys talk that there is an agreement being offered to you that if you plead guilty to the first offense of operating with your license suspended, the notice for second offense, which enhances the penalty, would be dismissed. Is that what you want to do? You're on mute now, Mr. Hargrove. You're going to have to take your, there you go. Is that what you want to do today? I'm sorry.
I just had a few questions.
Well, you're going to need to talk to your attorney about those questions. Do you need some time to do that?
He can't answer them for me.
All right. Well, then what are your questions? Let me see if I can answer them for you.
Okay, well, I don't understand how you can be the trustee of my SOVCIT KV account, Ronald Gene Hargrove II, and not have my best interest.
I'm sorry, what? I don't understand what your question is.
How can you be the trustee of the SOVCIT KV account, Ronald Gene Hargrove II, and not have my best interest?
What is that account that you're referring to?
Oh, God. The SOVCIT KV account that everybody has, most people have, and you're the trustee. Just like the Secretary of State is trustee of it. You are my trustee, aren't you?
No, and neither is the Secretary of State, and while this judge may be fairly new, he already looks more than capable of handling this oxygen thief without missing a beat, which means it's probably time to ask the 93-day question: have sovereign citizens ever actually won a case using these Huffle duster word salad arguments, or does it always end the same way?
Not that I'm aware of.
Uh-oh.
Why would I be your trustee? Mr. Gila, do you have some additional information that I'm not picking up on?
No, Judge.
It's just something that I believe in, and I've seen evidence of, and
what leads you, Mr. Hargrove? What leads you to believe that I'm your trustee?
Because of a former case I've seen.
A former case? What former case are you referring to?
In Roscommon, a friend of mine asked the judge that, and he couldn't answer him. So
That's probably because it's not factually true. What information do you have that leads you to believe that I'm a trustee for you?
Dishonor. In that case, the judge quit 6 months into his new term because he was dishonored, and the sheriff.
Citation definitely needed, because I'm going to need real proof before believing that some random sovereign citizen uncovered a magical get-out-of-crime loophole and somehow managed to get a judge and a sheriff fired along the way without a single court record to back it up.
So,
Mr. Hargrove, the question was not about a Roscommon County case. It was about this particular case. You've alleged that I'm your trustee. I'm asking what information or proof that you have that is true.
So you're just denying it?
I don't know of any information that it makes it true.
Okay. If it was
what information do you have?
If it was a misdemeanor,
go ahead.
If it was a misdemeanor, would it be true?
No. Misdemeanors and trusts have nothing to do with each other.
Okay, well,
there has to be some court order for me to be a trustee for you. For anybody to be a trustee, there has to be a court order. Do you have such a court order?
No. I just believe that you are my trustee of the SOVCIT KV account, Ronald Gene Hargrove II, and that's.
Could you speak a little more clearly and tell me what that account is?
I'm not sure. I just believe that you are my trustee, and if you deny it, then you deny it. Okay, we'll move on from there. I guess. You know, and another thing is, I paid $1,000 for a reinstatement fee, but you guys keep saying I don't have a license. And where did my $1,000 go? I don't understand this.
Who did you pay $1,000 to, Mr. Hargrove?
The Secretary of State or the State.
Then you need to ask the Secretary of State.
Well, I believe I have my license, and they just keep. There's a screw up somewhere.
Then you need to contact the Secretary of State. But I'm not connected to the Secretary of State. I'm the court system. I work in the court system. I don't work for the Secretary of State, so I can't tell them what to do. If you believe that you paid the money and you should have a license, you need to contact the Secretary of State.
Okay. Well, knowing that I think I had a license at the time, doesn't that change things?
It would change things only if it were true, and I don't know that it's true. Just because you believe it doesn't make it true.
Yeah.
Well, thanks a lot, Judge Hesseling. You've been on the bench for less than a month, and you're already finding new and impressive ways to ruin Christmas and Easter for the most gullible courtroom clowns out there, showing that it doesn't matter how fresh the robe is, reality and consequences still arrive right on time, especially for sovereign citizens who think word games can cancel court orders.
All right, Mr. Hargrove, your attorney has told me, and the prosecutor has agreed, that there is an offer on the table for you to plead guilty to operating with license suspended in exchange for dismissal of the second offense notice, which makes this a much more serious charge.
Okay.
Do you want to accept that today, or do you want to have some additional time to speak with your attorney?
No, they don't have nothing to say to me. Their best interests is of the court. So I'll take that, and I would hope to get the same fine everybody else did today. Thank you very much.
Well, I can't guarantee that because you're in a different circumstance than everybody else.
Well, I'm pleading guilty to the same offense they just pled guilty to.
But your background is not the same as theirs.
You know what? I'll plead insanity.
All right, now that's wrapped up, and I believe that the hearing has been rescheduled for a couple of weeks out, and I can't imagine the next one being anything less than absolutely insane, literally. And speaking of insanity, we now move on to our next hearing, featuring a young man who insists he can prove his innocence purely with facts and testimony, yet refuses every bit of help from his public defender, setting the stage for a showdown that's equal parts stubbornness and chaos.
What's your name?
Oh, you were up for an arraignment this morning.
Yeah,
that was at 8:30.
Yeah, I dropped my son off at 8:30. I didn't know because the court didn't open.
Okay, so what we have to do,
I'm trying to figure out how to get it.
Well, I don't think you're going to. You're not going to. I don't think you're going. Are you going to have time to address that? You want to go through an arraignment?
Please.
That's fine.
Thank you.
Then you go discuss it with Mr. Sierra.
We talked already.
What's that?
We talked already.
You already talked? All right. Well, let me finish.
Form's already submitted.
Okay, let me take care of these here quick, and I'll just get right to you. Let's go in the record in the matter of People State of Michigan versus Brown, file 2444177FY. And state your name, sir.
Quentin Brown.
Assistant Public Defender Dario Sierra appearing on behalf of Mr. Brown for the purpose of arraignment.
Very good.
We have reviewed that felony file. I waive reading at this time. I'm speaking with him. He has asked that it's set for the probable cause conference in the prelim. After he has just advised now that he would like to self-represent. So court-appointed attorney is being denied by Mr. Brown.
Well, it's not being denied.
He was previously
declining
granted,
to accept it.
so
All right. You sure about that? You want to represent yourself when someone goes to school for many years to learn how?
I know what's going on better than anyone that can, because it's not right.
Yeah, you absolutely have the right to represent yourself, but that doesn't mean you should any more than you should walk off a tall cliff with a rocky bottom. I get it. You believe in your heart that you're innocent and that you have all the proof needed to clear your name. The problem is the court has rules and procedures that must be followed to make sure that evidence is properly admitted, and lawyers know this inside and out. It's literally their job, which is why judges will always advise even the self-proclaimed innocent that it's in their best interest to let an attorney handle the case before ever suggesting anyone go pro se.
It is your right. It's your absolute right to represent yourself. The point of I just want to.
I got proof.
Hold on. Okay.
I just want to talk to the prosecutor in my case.
Okay, and that's fine. I'm just gonna right now. What I say now for the next moment is going to be something I want you to listen to, only for the sake of protecting you. The only reason I'm making the statement is to protect you from yourself, which I have to do a lot with people. Okay. So this is not just a matter about you, it's a matter about anyone that wants to represent themselves. I go through this with, okay? And what I want to be sure is to not have you make statements right now about the case, because we're on the record and I don't want anything you say now to be able to be used against you as you go forward, okay? That's just to protect you. That's the only reason I'm saying that, all right? What I want to also go into is the fact that I'm going to give you the spoiler alert. You absolutely have a right to represent yourself, so I'm not going to, you're going to have that right. But I want you to be very wide-eyed and thoughtful about whether or not you want to have someone who is, who does this for a living, who is here, they know all of the laws, they know all of the various potential defenses and discussion points that they could have with the prosecutors to probably assist you in using your knowledge. So if you say you know all there is to know about your specific case, and that's probably true, no one would know that better. But if you combine that with the know-how of a prosecutor, of an attorney,
they won't represent me like I'm innocent and protect me like I own my life and my freedom.
My understanding of the quality and caliber.
They offer me deals, and the prosecutor, I'll never get the chance to speak to him.
I know it's a bit hard to hear, but it looks like he's upset about his defense attorney receiving a plea offer from the prosecution and passing it on to him for consideration, which is literally what they're supposed to do. He seems to believe the public defender accepted a plea on his behalf without consulting him. But as you'll see, that's just the tip of the iceberg. There are plenty more things he's completely misunderstanding about how this all works.
They have an absolute requirement when the prosecutor makes what is known as a plea deal or a plea negotiation. They have a responsibility. They have ethical responsibility to share that with you. That's your decision. But they have to present it to you, at least for you to make that decision. But when I appoint an attorney to represent you, you're that attorney's boss. And if you decline a plea negotiation, then it's declined. That's up to you, not to them. So, like I said, I'm gonna go ahead and indicate here that you wish to represent yourself. That's fine if that's what you want, but I would be thoughtful about that, because again, this is what they do for a living. You see what I'm saying?
Well, I know in court that they had to find me beyond reasonable doubt, guilty beyond reasonable doubt.
That is true.
I felt comfortable representing myself because I know for a fact I'm innocent and I haven't committed any crimes.
Okay. Well, okay,
but
and that's fine. We can
else you can represent. They don't know. They don't know.
Well,
100%.
But
they can go home and sleep and be like, they don't know me. Okay. They don't know.
All right.
If I did these things.
Here's the thing. What happens though at a trial, if you're representing yourself, and again, the end result of this is you're going to be able to represent yourself if you want, but it's going to be not you. It's not going to be a judge, and it's not going to be the prosecutor that makes a decision as to whether or not you are indeed guilty. It's going to be a jury.
I know.
And they're going to have to, and they're going to
be you.
It's not going to be me.
Or whatever it is. I guarantee you, you will be changing this verdict.
I'd be genuinely shocked if he managed to tie his own shoes this morning without Alexa giving verbal instructions, and this is exactly why he shouldn't be representing himself. The verdict is the final finding by the judge or jury. It comes at the end of the trial, not at your argument, and definitely not before. And if you're sitting there claiming you'll overturn a verdict by the end of this trial, what you're really admitting is that you expect to lose even with all your so-called exonerating evidence, which is exactly why having an attorney is not optional.
Okay, the question is, and I don't know what your evidence is, but the thing is, if you have an attorney to assist you, that helps you get that evidence in, because there are some things that cannot be brought into court, and they know those rules. I don't know if you do or not. Maybe you do, but if you do, that's fine. But there are some things that cannot be brought in, things that are considered hearsay, things that don't have a proper foundation, things that may not be authenticated.
Well, Cash like you paying me on the table. And
Mr.
like,
You're on the record right now.
I don't want you making any statements, sir, that is going to incriminate yourself. I
It's not
don't.
going to incriminate me, sir.
Anything you say
All
though,
right.
sir, can be used against you. because
Exactly.
This is a court record.
Yeah, exactly. I just don't want
I'm gonna
anything.
use that in court. I'm in court now.
You are in court and they can use
This
this
is my
record.
defense. This is
All
what
right.
I'm going to use.
That's fine. All right. I'm going to go ahead and indicate that you're declining court-appointed attorney. That's fine.
That's what I'm saying. Like he right here, you don't even want me to get my record across. This is what I'm here for.
Well-
I came in good for it because I want to press charges against him. I want to talk to the sheriff after this, and Mr.
All right.
State Police,
This is
and I have
this
my
is-
evidence.
This is my concern, is that you don't fully understand the process. And that is not to say that you are not intelligent or anything. This is not what you do for a living. That's why most people wouldn't understand the process. But if you're determined to represent yourself, and I've tried my best to convince you, maybe you want the assistance of someone to help you. But if you don't, I'm going to indicate you're denying the request for court-appointed attorney. Now we have to address bond.
I just don't feel like they would take care of my.
Okay, but that's not been my experience. My experience is that they are very effective, but okay. We have a $2,000 personal recognizance bond, and I am going to continue that. And then now, the dates for the probable cause conference are as December 5th, and the preliminary examination, that's going to be December 10th. That's going to be at 9 a.m. That's the prelim. And the probable cause conference that on December 5th, that's at 1:00 p.m. Okay. Now that one you can attend by calling in and discussing the matter with the prosecutor. I'm giving you notice right now.
No, like paper notice.
You're going to get, they'll send notice.
I could forget.
Well, you've got to write it down because I'm giving you have notice right now, sir. This is your notice. Yeah. So if you don't show up, you're not going to be able to come here and say that you didn't get the notice because a bench warrant will definitely.
At 9 a.m. for what date?
9 a.m. on December 10, 1 p.m. on December 5th.
December 10, 9 a.m. Could this be appeared by Zoom?
The December 5th, you can appear by Zoom. December 10, you have to be here physically.
All right, so that wraps up the video. He had a pretrial conference on the 5th and a pretrial hearing on the 10th. The hearing wasn't broadcast, which leaves us with 3 likely possibilities. The least likely is that he didn't show up. He seemed invested in the case and confident he could win, so I just can't see him missing it, unless he completely forgot the date. The second possibility is that he had that Zoom call with the prosecutor on the 5th, and they either worked something out or the prosecutor reviewed his evidence and decided to drop the case. The third scenario, which is probably just as likely, is that after the call they decided to move forward with trial, and he got a continuance to prepare for a pro se defense. I follow this courtroom closely, so if he returns for a future hearing, I'll be sure to keep you updated. Until then, if you like the video, hit that like button. If not, hit dislike. But don't forget to comment below and subscribe with notifications on. I'm Team Seju Shah, and I'm out.